has seen all the stages and phases of the implementation of the agreement as former official of Labour and Social Security, who has served in several EU countries, just lately Holland, Belgium, Sweden, and finally in London. I have seen the implementation and the visa type, which is referred to as Ankara Agreement visa, two categories in several countries. I have seen a lot, and I can say that in the last 10 years it was quite steady, stable, and all of a sudden this ILO agreement, this ILO judgment came out unexpectedly, and it caused a lot of disturbance, of course. Well, just let me give you some maybe 5-minute background on the whole thing, just to put the thing into right context so that maybe it could be useful, helpful for the audience. You know, the Ankara Agreement is the association agreement between Turkey and European Union, European Economic Community back then, to prepare Turkey in gradual stages for accession to the European Union. Of course, it wasn't all about free movement of workers, it was all about everything, customs union, how Turkey could accede to the European Union. It put the principles, and then there was second legislation like additional protocol, association council decisions, a lot of preparation, a lot of work. But the relationship between Turkey and European Union has never been smooth and steady, and it is as long as my age, maybe. Well, it has been all quite troublesome, with peaks, it had its peaks and it has its downs. There were phases, there were stages when everything was frozen or suspended, sometimes one-sided by the Commission. Just to give an example, the deadlock, for example, after the military coup in 1980, the Commission suspended free movement of workers one-sidedly for years, and it was just blocked. There was no communication between two parties at all. But at the same time, we have Turkish workers. Then we used to call them, as you know, I'm a former official of Labour and Social Security. There was a time we referred to these Turkish workers as guest workers, you know, especially in Germany, 3 million, more than 3 million in Belgium, in France, in Sweden, in Holland, everywhere, all over European Union. There were these Turkish workers, and we had their immigration issues. They couldn't look up to this agreement and the implementation of the agreement because Turkey could never, it was being delayed all the time. You know, there were lots of political problems between two sides. I think I can make myself work, right?
Yeah.
I think it will be better if you don't use the microphone because people can't hear at the back.
You can. Can you hear me now?
Yes.
Okay, that's better. Okay, that's better. Let me get adjusted to that. All right. So where were we? Yes. So there were problems. There were immigration problems of Turkish workers abroad, and then some representatives, some legal representatives of Turkish workers started to explore ways of bringing some solutions to these problems. And they started to question whether Ankara Agreement could be used in that respect. As you know, you have to be a member of the European Union so that the cases of your citizens can be referred to the European Court of Justice. That was not the case. Turkey could never be a member, and it was all the time being delayed. But they said, well, if Ankara Agreement is an integral part of European law, then maybe, even if Turkey is not yet a member country, maybe there is a possibility that the Turkish citizens' cases could be referred to the European Court of Justice. This was something which had never been tested before. It was simply impossible. Nobody had thought of that. But the relationship was so unique that they started looking for answers within law. And then the first test case was sent to the European Court of Justice just to try to get the response of the European Court of Justice. The first case was sent in late 80s, because the relationship, there was a big deadlock, you know, it was totally frozen. They said, is Ankara Agreement an integral part of community law? That was the first question. If it is so, then can Turkish blah blah blah? It went on like that, and the answer was interesting. The court said, yes, exactly. The Ankara Agreement is an integral part of the European law, and therefore Turkish cases can be referred to the European Court of Justice. Although the second part was not so positive, because they said Article 12, which is about free movement, does not have direct effect, which didn't favor Meryem Demirel, the holder of this case, but it paved all the way for Turkish cases to be referred to the European Court of Justice, and it was a very unique development, because it was the first time such a thing was happening. It was 1986 when we had Meryem Demirel judgment, which opened or which paved the way to all these cases. And from 1986 till 2000, there were more than 50 cases, but judgments, which even broadened the scope of Ankara Agreement, because whatever was embedded in the legislation, in the law, was very broadly interpreted by the court, because, you know, the European Court of Justice tends to give legal interpretation and is in favor of free movement. Therefore, it provided broad rights, even making these rights kind of larger than actually people thought they were. So very favorable judgments came out. But they were all about Turkish workers, only people who were employed, not self-employed or not business people, like now ECA two-category visa. It was all about workers. And in 2000, something happened. A very interesting judgment came out, to our surprise. I was in Brussels then, working as Attaché of Labor and Social Security, and the judgment for the first time was related to the situation of business persons, as we call them now, or people who set up their own business and settle in a European country. It was 2000 that Savaş judgment was concluded, and it was really, it echoed very well in Brussels. We had several meetings, universities had meetings, and everybody said this decision, this judgment is going to have great impact on the future of the implementation of Ankara Agreement. It was 2000. I went back to Turkey because I was posted, my posting was over in Brussels. I went back to Turkey and stayed there for 5 years, kind of a little bit cut off from this process, and came to, posted to London again in 2005. When I came here, I found out that the UK, because they have respect for rule of law, had transposed the interpretation of this Savaş judgment, which was very important for self-employed people, people who set up their business. They had transposed it to their national legislation, which meant they had opened a second new category to Ankara Agreement visas. There was only ECAA 1 for workers, but now came a second category for those people who would like to establish here, settle, and provide services. Because Savaş had brought interpretation to 41 of additional protocol, which said no new restrictions can be introduced to the rights of Turkish workers who would like to establish and provide services in EU countries from the date when this agreement went into force. That means it was a standstill clause. If the UK, not if, you know that UK became a member of the EU in 1973, then the UK was expected to freeze the legislation which was valid for people who wanted to establish in the UK there with the same conditions, and even if the UK changed its legislation, that couldn't be applied to the Turkish self-employed. They had to implement the legislation which was there in 1973. That was the meaning of standstill clause, which had great implications. Then, okay, in 1973, people could come over here much more easily, you know, because there hadn't been so many amendments in legislation. Anyway, Saad will explain it to you that we had several judgments on that basis afterwards, and with every judgment the position got strengthened and strengthened, and Home Office even refused to have, for example, these visa categories were not on Home Office web pages, but we started a permanent dialogue with the Home Office Consulate and the Home Office. We started, when I started in 2005, I realized that there were problems in the implementation. We immediately set up a committee which was in dialogue. 4 times a year we would meet and discuss these, and a lot of improvement was provided. For example, there was even, I mean, people didn't know about that, it wasn't anywhere. Now we put it on the website. We, of course, we didn't put ourselves, but we made them put it on the website, and this dialogue really helped restore things and make things more steady and stable. Until when? Until 2017. And what happened then? We had this idle judgment. In fact, it was just a partner of a self-employed person who was the holder of Ankara visa who made an application for indefinite leave to remain, which was for her residence. It was refused, and she sued it. It went to the upper tribunal to cut it short, but the upper tribunal did something. It said the settlement, giving ILR indefinite leave to remain or settlement of migrant Turkish people and their family members do not fall under the category of this standstill clause, because the standstill clause does not necessarily say that they should be given, settlement. They can exercise their rights free of that. So this standstill clause does not apply to, for example, when it comes to indefinite leave to remain or things like that. And then it was a shock, because in 1973, indefinite leave to remain to business persons was given after 4 years. That's why Home Office has been implementing this for so many years, for maybe nearly 10 years now, that they were giving indefinite leave to remain in 4 years. But when the ILO judgment said this clause does not, is not valid for this, for settlement, all of a sudden people didn't know what to say. Okay, 4 years. If it's not 4 years, how long? Home Office was quiet for a year, but they had to react and said on the 16th of March, well, we have to interpret the judgment of IDOTU and make some amendments to the legislation. And all of a sudden, they said there would be different rules which are to be introduced to indefinite leave to remain, or to their residence rights. And of course, it triggered a lot of disturbance, because especially in recent years, there are thousands of people who have signed up for a project for 4 years or maybe 5 years, but they don't know how long this will go on and when they will get their settlement. And they say, this is not something we've signed up for. We haven't signed up for this. So what will happen? The rest, we don't know. I think nobody in this panel knows. But everybody is trying to do something about it. Of course, legally, what can we do? What can we do? Just maybe talking to Home Office, what can we do as NGOs, as meetings like this, just discussing. So we should try our best to affect the Home Office in the best way, that the guidance, when it comes out, we are not terribly disappointed. This is why we are here in this hall, trying to find answers all together with you. And these people who have recently come are quite different from those 10 years ago when I was dealing with these. People couldn't even get together and have petitions, but now there are lots of people who are really intellectual and trying to do something. We'll see what we can do. So sorry for this maybe long introduction. I didn't want to steal from your time, but as somebody who has seen all these stages, I think we have to see where we came from and where or how further we can go. Okay, thank you. Now, please, Sam.
To give to the Ankara Agreement to set up the history. And I think the theme that we get from what's happened since the UK became a member of the EEC, or what we now call the EU, is that over time there's been a battle where doors have been broken down consistently. People have been pushing. The government of the UK, in its interpretation of the Ankara Agreement, has been trying to close that door, but repeatedly through legislation, through cases within the UK, within the European Court of Justice, those doors have been opened, and they continue to be opened. And my colleague to my right will speak to you about the recent judgment where it seems as though the doors have been shut, but it may not necessarily be the case. So I'm going to talk about the case which happened, I would say in the early 2000s. The actual judgment was in 2007, but the case started long before that. There were a couple of gentlemen called Mr. Tum and Mr. Diary, you may be familiar with them, who wanted to exercise their rights under the Ankara Agreement. So, being Turkish nationals, they came to the UK. Originally they made applications for asylum, which weren't successful. But then after those applications, they decided to start providing services to people in the UK through their businesses. And they had a very simple proposition. The proposition was that the Ankara Agreement allows me to remain here to provide those services, regardless of the fact that I have claimed asylum, regardless of the fact that I may have entered the UK illegally. And in my position, I think I should be given the reason to remain here. Now, as I've said, the Home Office consistently denied them the opportunities. And it wasn't really until they got to the Court of Appeal in the UK that the door first opened. And Lord Wolfe, in his judgment, gave a very, very interesting analysis about the Ankara Agreement and about the state of the law in the UK, which I won't bore you with. But essentially, like I said, he opened the door. Although the Court of Appeal did not allow the appeal in the long run, Mr. Tum and Mr. Diary took the case up eventually to the European Court of Justice. Now, the European Court of Justice is, of course, the guardian of community law. It provides what is the ultimate interpretation, which is to be followed by all members of the European Union. And it said very simply this: the Ankara Agreement does have a standstill clause. Everybody knows that. The standstill clause, and I will read it out to you, read out the pertinent part. The first part of the standstill clause says that the contracting parties, i.e. the governments of the countries signed up to the Ankara Agreement, shall refrain from introducing any new restrictions on the freedom of establishment and the freedom to provide services. So it's all there, it's in plain English. And the European Court of Justice said to Messrs. Tum and Diary, it doesn't matter whether you entered the UK illegally, it doesn't matter whether you've claimed asylum, you are allowed to take the benefit of this provision. So the UK is not allowed to apply or introduce any new restrictions on the freedom of your establishment or your freedom to provide services. And this was quite a game changer, because the position of the UK government was that they wanted Messrs. Diary to fall under the legislation as it was at the time, which required them to have £200,000 in cash, amongst other requirements. Messrs. Diary obviously didn't have that much money. They had businesses, but businesses which were on a smaller scale. And the relevance of this judgment was that if the UK is not allowed to provide any new restrictions, then we go back to the laws as they were in 1973, the date that the UK joined the EU. We look at the laws as they were then. If they were more beneficial, which indeed they were, then they can take advantage of those laws, and as long as you meet those laws, you can apply and be given a visa to remain in the UK. So in my opinion, and in many others' opinions, a very, very big door was opened on that day. Now it has to be said, although the European Court gave this judgment in 2007, in my experience in the courts, in the lower levels and in the higher levels, the UK courts and judges have still struggled to really apply and understand this judgment. And the reason I say that is because the freedom of establishment, the freedom to provide services, not only applies to what we call legal requirements, as I've talked to you about the immigration laws, but also to procedural requirements. It's much more wider than just meeting legal requirements. So, for example, if in 1973 the system of making an application to remain here was easier than it was now, if it did not involve a fee, as applications do now, then those fees are more restrictive, that procedure is more restrictive, and that should not be applied to Turkish nationals. And like I said, in my experience, the courts have had difficulty in really reconciling this and accepting that this is the true meaning of the standstill clause. We move on to other procedures. So, for example, in 1973, a Turkish national didn't actually have to apply from Turkey. He could turn up at the airport or at the seaport and present his application, which nowadays is frowned upon. It's still not illegal, but it is frowned upon. Also, in 1973, when a person did that, if the person deciding the application at the port was not satisfied that the application could meet the requirements, but thought, well, we need time to consider this, then they were allowed to grant a visa of 2 months to people to enter the UK while their applications were considered. You don't see that nowadays, at all. You either apply for entry before you come to the UK, or if you want to apply at port, you're either going to be refused or granted. That's it. So the spirit of the Ankara Agreement, as I often remind the judges, is that we have to remember what the Ankara Agreement is about. We have to remember that the Ankara Agreement came about to facilitate the entry of Turkey into the EU. The spirit of the Ankara Agreement was to break down the barriers to ease Turkey's accession to the EU. It was thought at that time that that would happen within 20, perhaps 30 years, and we know now that hasn't been the case, but the spirit of the Ankara Agreement still remains. And the spirit of the agreement, in my opinion, in my humble opinion, is very, very important, because at the end of the day, that's what we're all here for. The agreement was signed in good faith, it was made in good faith, it was negotiated in good faith, and the rights which stem from that ought to be applied fairly and correctly as well. So as I said then, in 2004, Diary did this, and they broke down a very, very important law. Now, as time has gone on since then, we are now 10, 11 years on from that judgment, there have been attempts by the Home Office in this country to again close doors following the judgment of Diary. So, for example, they've introduced arguments such as, if you commit fraud in entering the UK, if you try to abuse your rights under the Ankara Agreement, then you fall outside of this standstill clause. You can't take the benefit, and so we can apply the more stricter laws that we have now. Time and time again, the Home Office has brought cases to the court, in which some of them they have succeeded, but in many others they have lost. Now, interestingly, I'll jump forward to a judgment from the European Court of Justice again in 2014. Because essentially, under the laws in 1973, we know that if a Turkish national was successful in getting the visa, initially they would get a 12-month visa. They would have the opportunity to set themselves up in business, start providing their services, and then make a further application at the end of that 12 months to get an extension of their visa. If successful, they would be given a further 3 years, and at the end of that 3-year period, the laws in 1973 said they could then apply to settle here permanently. Now, in 2014, there was a judgment from the European Court of Justice where a person had done exactly that in Germany. And under German law, as it was at the time, not in 1973, but at the time, if he wanted to bring a spouse over, I think that the German law required that the person had to do a test in German or something like that. It was an additional requirement. And the European Court of Justice said something very, very important. They said that even though the Turkish national has got his settled status in Germany, he still is able to benefit from the standstill clause. So you can't apply any further restrictions that were in place compared to when you became a party to the Ankara Agreement. And not only does that apply to the actual person who is setting themselves up in business or providing the services, it applies also to their family members. And the European Court of Justice was very clear about this. So the European Court of Justice, as I said earlier, is the ultimate guardian of the interpretation of community rights. They are the ones who tell us how it is to be applied and how it is to be interpreted, and they've been very, very clear in this regard. How that reconciles with the recent judgment, I can't really tell you. I think the judgment is wrong, but nonetheless it has to be respected because it is from a judgment of a judge in the UK. But it doesn't stop me from saying that it's wrong, in my humble opinion. But that gives you the essence of the spirit of the Ankara Agreement. As you were told in the introduction, the way in which community law is interpreted is to be very broad, is to be very wide. It's not to be narrow or specific. So again, I come back to the spirit of the Ankara Agreement. The spirit, as I said, is to allow Turkish nationals to provide these services, to establish themselves, not only in the UK but across the EU. The agreement was negotiated and made in good faith. Surely these rights have to be applied and given. Thank you very much.
The Papal Tribunal in March 2017, because the Home Office simply said that when they announced the changes in March this year, they said that they were simply implementing, giving effect to a court judgment. I have formulated 2 questions which I'm going to have to answer myself as Home Office is not here. The first question is, was the Home Office obliged to give effect to the ILO decision? I think that the answer to that is simply no, because first of all, as has been explained earlier, this decision was concerned with the spouse of a Turkish citizen, not the main applicant himself. And so anything that was said in the judgment which dealt with the main applicant is what is called in legal terms so it's simply advisory, and the Home Office is not obliged to follow it. It's not binding on any of the parties. The other issue with that is that in the judgment there's no mandatory order, nothing that basically says that the Home Office has to make any changes or take any positive steps to implement this decision. In this case, it was a matter of choice for the Home Office to simply decide to make these changes. It wasn't a case where the Home Office was under any obligation to make those changes. That brings me to the second question, which is it wise and is it correct that the Home Office is actually trying to implement this decision? And again, my answer to it is going to be no. The reason for it is that with respect to the Honourable Judge Mr. Justice McCloskey, who gave the judgment, I believe that Aydordu was wrongly decided. And the reasons for saying that is as follows. That the first reason is that the upper tribunal stated that settlement applications by Turkish citizens and their family members are not covered by the Ankara Agreement. So the first application and extension applications are covered, but when it comes to settlement applications, the Turkish citizens wouldn't have the protection of the standstill clause in the Ankara Agreement. So as Mr. Said earlier said, this is not in line with the general jurisprudence of the Court of Justice of the European Union. There are several cases in which the court held that Turkish business persons and their family members would continue to benefit from the standstill clause even after they have gained permanent residence in the host member country. An example of that is the case of Doğan, which again has been just mentioned by Mr. Said, in which Germany tried to introduce a language test requirement similar to what we have here in the UK. And the court simply said that this is not applicable to the spouse of a Turkish person who had a self-employed business in Germany. Again, it's worth actually emphasizing that this Turkish citizen in Germany didn't even have leave to remain under the Ankara Agreement. He was simply there as a Turkish citizen, and he also had a self-employed business. The Court of Justice even went further in the case of Kahveci and said that even after the Turkish citizens have obtained citizenship of the member state, they continue to benefit from the protection of the Ankara Agreement. Based on this, I believe that the Aydordu decision was not correct. The second reason is that the upper tribunal said that because Turkish citizens qualify for settlement once they've completed 4 years of residence, whereas EU citizens would gain settlement after 5 years of residence, this amounts to giving Turkish citizens superior rights. Again, this is based on a misconception. This is not the case, because in that situation, the court is simply comparing two different classes of people. Just to give a few examples, EU citizens do not require entry clearance. They don't have to apply for a visa to be able to come to the UK, whereas Turkish citizens would have to apply for entry clearance. Turkish citizens would need to obtain permission from the Home Office to be able to set up their businesses. EU citizens don't have that requirement. EU citizens can work as an employee or self-employed persons, or they can combine both of these, whereas Turkish citizens are just limited to self-employed work. EU citizens, where their income is not going to be sufficient, can make recourse to public funds. They can apply for benefits. Turkish citizens cannot. So these are important distinctions, and the court simply ignored these distinctions. Another technical point, but in my view important point, is the fact that EU citizens are being given substantive rights under EU legislation. So their free movement rights are clearly protected, and they are prescribed in law, whereas Turkish citizens only have a procedural protection, that is the standstill clause in the Ankara Agreement. So based on all these, it is not correct to say that Turkish citizens are being made a favour just because they qualify for settlement in 4 years rather than 5. Two more things to add. The third reason is that the court said that settlement is not necessary to effectively manage a business. And again, I believe that this is wrong. It depends on the circumstances of the individual. Say, for example, you are a business person and you would like to expand your business. For example, you might need a bank loan and if you apply to the bank, obviously your immigration status is going to play a role there. And so it is not, again, correct to say that settlement is not needed for effective running of a business. To be fair, the court did say that in some cases a fact-sensitive analysis is needed, so in some cases settlement might be necessary, but again, it was, in general terms, it is wrong to say that settlement is not part of the right of establishment. The fourth reason why the case was wrongly decided is the fact that the changes which were brought about in relation to spouses gaining settlement, the 2 years residence requirement, it was brought in by way of a policy change. It wasn't formulated as an immigration rule, so it wasn't laid before the Parliament. And this type of changing rules, which might lead to a refusal in an immigration application, has been found to be unlawful by the Supreme Court in a case called Albi. The final point I'd like to make here is that we, as the panelists here, are not alone in believing that the Aydordu decision was wrong. There was the case of Yasemin Üstün by the Honourable Mr. Justice Collins, where the Honourable Judge simply said that he had his doubts about the correctness of the Aydordu case. So this gives us some comfort and confidence in relation to bringing more challenges against these changes that have been brought about. Thank you.
Thank you very much. How Brexit changed the legal landscape?
Yes, thank you. Let me give you a scenario. What if tomorrow the British government made an announcement suddenly and they said that they're immediately withdrawing all their negotiations with the EU, and the EU nationals' right to gain permanent residence in the UK was withdrawn? What would happen if the UK government tried to use any of the EU citizens' rights as a bargaining tool? There would be an outcry from the EU nationals or the countries involved. Well, this happened to Turkish nationals recently. So in March 2018, Home Office made an announcement and said that under the provisions of the Turkish business, there would be no right for settlement for a Turkish business person or their dependents. This was confirmed by the Aydordu case. Now, put it simply, this was a shock for many Turkish nationals, and many of them felt betrayed. I would like to look at this issue in a different angle. I think we need to look at the roots of the Ankara Agreement and the principles of the Ankara Agreement as well. If we go back to the Second World War, just after the Second World War, it has ended leaving most of the countries in short supply of labor, resources, and political stability. The Cold War has just ended, the Cold War just started. So on one side you have the NATO countries, and on the other side you have the Soviet Russians. This paved into the formation of the European Economic Community in 1957. So, and of course you have Turkey in the middle. Turkey did not participate in the Second World War, so it was relatively in better position. So Turkey was also a NATO member since 1952. Turkey's agreement with the European Economic Community was a strategic move by the EU countries to pull Turkey to their side, not towards the communist Soviet Union. So in 1963, the member states of the European Economic Community and the Republic of Turkey signed Ankara Agreement. So this establishes the association between the European countries and Turkey. The basic objectives of the Ankara Agreement were to progress trade and economic relations between Turkey and the European countries. This was coupled with the establishment of customs union in 3 phases. Now, when we talk about Ankara Agreement, most of the people actually just think of the main principles of freedom of movement, freedom of the workers, and right to establish businesses. But it had a different aspect to it as well. So the customs union, which came into effect in 1995, so it's Gümrük Birliği in Turkish. Under this customs union, goods may travel freely without restrictions between the contracting parties, or between EU and Turkey. There were further provisions under the heading of other economic provisions. Now, this is the section that involves us very much. Under the Articles 12 and 14, it talked about the freedom of movement of workers, freedom of establishment, and the right to provide services. The abolition of restrictions on these core freedoms are identified as one of the principal mechanisms designed to facilitate trade and economic relations between Turkey and the EC countries. And there was the additional protocol that was signed in November 1970, and it has that standstill clause that we've talked about, which states the contracting parties shall refrain from introducing between themselves any new restrictions on the freedom of establishment and the freedom to provide services. Now, the United Kingdom became bound by Ankara Agreement and the additional protocol on January the 1st, 1973. This was in line with the UK's accession to the European Union. So if you ask ourselves what happened after the state in terms of the Turkish nationals' freedom of movement and established services in the UK, nothing much has happened until the early 2000s. So in 2007 we had the case of Tümen Dadı, and among with other important rulings, it changed the whole landscape in the United Kingdom. After the long legal battle, the United Kingdom had to accept the rights of Turkish nationals for freedom of movement and establishing services in the UK. And they also had to accept the provisions of the Article 41 of the Additional Protocol. So with this either the case, there's an argument whether the UK government will bring forward new restrictions on the Turkish nationals' rights. So if you go back to the immigration rules in 1973, the paragraph 28 provides that at the time, any business person, so a Turkish business person, after 4 years of economic activity in the United Kingdom, they could actually get indefinite leave to remain in the United Kingdom. Now, if you look at the current situation, the rules or the requirements for indefinite leave to remain or settlement has been evolved, and they have become more increasingly strict and demanding. There are language requirements and financial stipulations as well. So, in the either case, the Secretary of State's stance was that the settlement for Turkish business persons or their dependents does not fall to be considered under 1973 immigration rules. And the rulings in these both cases were the same, unfortunately, that the judges believed Turkey has, although at all material times been involved in this agreement, they were not a member state of the European Union. And taking into account of the recent history, the judges actually commented that Turkey has not even achieved the status of a pre-accession state. So it was decided that it would not be consistent if Ankara Agreement, an additional protocol, were to provide Turkish nationals rights superior to those available to EU nationals at the time. So currently, the EU nationals obtain permanent residence after 5 years of continued settlement in the UK. But at the same time, UK voted to come out of EU. We know the current political situation at the moment. There is a public hostility against immigrants, and the whole political landscape has changed. I believe the decision itself does not parallel with the principles of the agreements. Although Turkey is not a member state, it still participates in the customs union, and the parties are still bound by the terms of the Ankara Agreement and the additional protocol. So if you look at the problem, or if you look at the issue on the other perspective, what would happen if Turkey announced that they are introducing new restrictions on the goods travelling between EU and Turkey? The governments of the relevant parties would simply not accept that, and they would remind Turkey of their obligations to say that Turkey would not be able to bring forward new changes or new restrictions, so to speak. So going forward, it's really difficult to predict what the new policy will be. Some argue that Turkish nationals will have their indefinite leave to remain applications granted after 5 years in line with the EU citizens. Some of my colleagues will argue that Turkish business persons will have to extend their visa until they reach 10 years continuous lawful residence in the UK, and then they will be able to apply for indefinite remain after that. But there will be for sure further requirements in terms of English language, and there will be a fee to pay as well. So if we look at the British government's stance over the recent immigration issues and also their stance over the Windrush generation issue, I believe the new policy will be a strict policy. And there will be further litigation, especially from those who are expected to submit their indefinite leave to remain applications in the near future. I think there's going to be a lot of questions about what needs to be done, but I think at this stage there is no transition provision in the in this agreement. The cut-off date that the Home Office actually provided is just the date that they chose, basically, and I think the current applicants should look to protect their rights. Although the relevant parties in this Idolda case did not take the matters further by going to Court of Appeal, I think further refusal should be appealed. And I think the Turkish government should do more to protect its citizens' rights. The Turkish consulate had regular meetings with the Home Office officials, and the Turkish consulate and its officials had important input with the Tumandaru cases. So I think both authorities should work together to ensure Turkish nationals who come to UK with a legitimate purpose to set up a business and contribute in the UK economy continue doing so without placing any further restrictions on their rights. And I think people actually should write to their local MPs. Although as Turkish citizens we don't have right to vote, I'm sure the local MPs will listen to the people's concerns, and they will hold the government's officials accountable for the new policy changes. Thank you very much for listening to me.
Finally, I give the floor to Semra Gülgür. I know Semra, when I met her, and I was working at the consulate, she was a new graduate who was full of excitement and yes, she's still the same. But now she's a young businesswoman who is the co-founder of Ashton & Ross, and she'll be our final speaker.
Hi everyone. As Ms. Ayşegül has stated, I started my career with Tumandaru, today's leading case. I was a trainee solicitor in the case of Tumandaru, and we did work a lot to succeed, and we did, and I believe we can do it again this time. I do agree with my colleagues that Idolda is a wrong decision, and I do believe that Home Office did not have to follow the direction to implement this. And I do have a question as to why did they implement it, and then why did they decide to implement it a year later? If they should have implemented it, they should have done it earlier and with a notice period. I'm not going to talk about Ankara agreement here at the moment because it's all set, and then I know everyone in this room knows about Ankara agreement too well, maybe better than lawyers, some of you guys. But what I want to talk about is how the Home Office breached the public law of UK. What they have failed to do is they changed a policy overnight. Of 16th of March, we all wake up to a morning where they have abolished the law or regulation and changed their policy and said your right of indefinite leave to remain has been taken away from you guys. Okay, good morning. Like, I have received thousands of calls on that day as to what's happening. There are Home Office letters issued to many of you guys with 3 years leave to remain Home Office letters, entitles most of you with indefinite leave to remain. I have spoken to 3 barristers on that day to get second opinion or third opinion, because I have never been a lawyer to say I know everything. Second or third opinion always matters. And opinions I have received, including Ms. Ayşegül, is to create a file to suggest Home Office or inform Home Office what are the rights we want in the new guidance. Because fair enough, they want to go through a new guidance or a new implementation, but there are rules that they should avoid putting or they should consider. The first of all is any applicant who made the application, even submitted the application, despite being granted or not, should benefit under the old rules. Because ECA is a scheme, or Ankara Agreement is a scheme, where actually UK is inviting Turkish nationals to say, come and settle in the UK. Bring your investment, bring your skill, establish yourself and your family in the UK, and we'll give you a settlement. You're not trying to get a right which is not given to you. They have given this right from the beginning, and therefore they cannot take this right away from you guys. My part that I have prepared to submit to Home Office includes more than 500 Home Office letters, which all states to people who has been granted 3 years leave to remain, saying you will be eligible indefinitely to remain. This has created legitimate expectation to all members of Turkish community, even if you're under 1 year, because you know the next application you're going to submit, you will be receiving one of those letters that states your right indefinitely to remain. Under public law, they have breached, they changed the rules and then they don't have any new system in place. Why don't you hold on to it, and until you have new implementation or transaction period, then abolish the old rules? They have failed to do this. They have done this in the past. In the case of Niyazi, I don't want to get into case law too much because this is not a law session, but they have failed to meet the legitimate expectation, and then the court has found that this is unfair. And then Home Office did it again, this time with Turkish nationals. If this to go to High Court or the Court of Appeal, this can be used again to suggest that it is unfair. What they have done to all the investors that move their lives, move their investments, move their skills to UK, you cannot say, hold on to it until I make my mind up. Once I make my mind up, I'll inform you. What is the time scale we're talking here? Are you talking about a month? A year? 2 years? You need to precise. Your Home Office and my life is dependent on you. My family's life is dependent on you. You cannot come and make a decision to change my life and without being precise. We want Home Office, or we invited Home Office here to make a decision as soon as possible, or at least inform us what is the time scale. I've been making further leave to remain applications instead of indefinite leave to remain for people who actually qualify for indefinite leave to remain. This is unfair. You cannot take the rights away that you have already granted. And then moving on, they have done this in the past, and I know because of the social media, most of people write there as well. HSMP Forum case has been the leading case as well, again, that is concluded in 2009, where they have tried to change the legislation to say that they should be getting 5 years indefinitely to remain rather than 4 years, which was under the old rule. The court upheld the decision and said no, under the old rules, if you have granted these people exactly the same as ECA case, that 4 years is when you will be gaining indefinitely to remain as such. And then if there is a standstill closure, you cannot bring any new restriction. I only want to invite Home Office here, which with the file that I have done, representation, if you even want to consider bringing new implementation, new policy, you cannot bring the old category or old applicants to the new category.
Fair enough.